Joining us now is Harvey Pitt, the former chairman of the Securities and Exchange Commission. It was Pitt who led the SEC in adopting dozens of Sarbanes-Oxley-related rules during his chairmanship. We are still waiting for final ruling and final word here, Mr. Pitt. But tell me, I mean, with the benefit now of hindsight, looking back at 2002 and Sarbanes-Oxley, should this public accounting board exist?
Oh, I think definitely there's an incredible need for this kind of oversight of the accounting profession, and the PCAOB itself has done a terrific job. In the light of hindsight, there are better ways to have crafted the legislation, but it nonetheless did the right thing in creating the PCAOB.
Well, we did just get the headline here that the Supreme Court has ruled that it was unconstitutional there. This, of course, getting to the question of separation of power principles. And as you were just referencing the PCAOB, as we call it here, the question is whether it lacked the constitutionally required presidential oversight. The court has ruled that it did indeed. I know, sir, you have said that a large part of Sarbanes-Oxley was sort of hastily rolled out. Was this part of that?
Well, I think this is definitely an unfortunate and serious blow. The court, during oral argument, was most concerned about the fact that the chairman and other commissioners of the SEC could only be removed for cause, and they in turn could only remove the head of the PCAOB for cause. And that is probably the part of the ruling that will need to be corrected and corrected quickly.
Because I believe that this ruling now, that the audit board violates the Constitution, now opens the window for Congress to reestablish the panel with tighter oversight here. So does that now mean that regulation gets further tightened, or do you see, given the other changes on the horizon with financial reform just around the corner, a complete overhaul?
Well, I think there are a couple of potential roads that this could take. First of all, I think those who opposed Sarbanes-Oxley may use this to argue that the entire statute is rendered unconstitutional because there was no savings provision in the legislation, which is to say that if any provision was held unconstitutional, the entire act would be unconstitutional. The other issue is the interaction with the pending regulatory reform bill. This would be a perfect opportunity for a very quick and simple fix, but the question is whether those who were troubled either by Sarbanes-Oxley or the financial reform bill will use that as a means of delaying one or both of those.
You do think that this could be used as a provision for someone to dig in their heels and keep this legislation from passing or getting to the president's desk before July 4th?
I think that's a very real possibility, although I think that Congress in general seems quite committed to financial regulatory reform. But in the 2,000 pages of the legislation that are presently before both houses, there's not a word dealing with the PCAOB, and I think that will have to be fixed.
We do have to leave it there, but I do want to ask you very quickly, sir, do you think financial reform as it stands, what we saw on Friday, is a win for regulators?
I'm sorry?
Was it a win for regulators?
Oh, I think it's a win for regulators. The problem is whether they'll be able to implement all the things that are in the legislation.
All right. Question we're going to try to get answers to. Thank you, Mr. Pitt.